In landmark verdict that has sent shockwaves across Tamil Nadu and the country, the Madurai District Court today imposed a double death penalty on all the 9 accused in 2020 Sathankulam father and son custodial murder case. In this regarding important judgment, I am in conversation with veteran legal journalist and constitutional law expert V. Venkatesan. Thank you so much for joining, Mr. Venkatesan, sir.
Thanks for inviting me.
Yes, sir. The 9 accused to double death penalty in this Sathankulam father son custodial murder case. Court has describing it's one of the rarest rare case. So death for 9 accused. Is it rare in India's judicial history?
It is indeed rare sentencing. In the sense, after the Bachan Singh judgment of the Supreme Court in 1980, death sentence is imposed only in the rarest of rare cases. Okay, but what is rarest of rare? Courts have differed from case to case. Basically, it is a gruesome manner of killing somebody, gruesome manner of murder that has always invited death sentence. Whereas in recent cases, you find that the appellate courts, the High Court and the Supreme Court, they have always been liberal in the sense of the trial courts impose death sentence, they commute it into life sentence for fixed terms, say 20 years or up to end of life. So like that. So that is why you find that after the Nirbhaya death sentences, there have not been there have not been any death sentence which is confirmed by the Supreme Court, because the Supreme Court there has been a lot of rethinking on the part of the Supreme Court judges that death sentence is not a deterrent as such. So that is why they think that whatever the nature of the crime, one has to look at the history of the criminal, the background of the criminal, not only from the point of view of the crime as such. So the crime may be gruesome, no doubt about it, may be heinous, but that alone cannot decide the sentencing part. So very often you find that the judges want the jail authorities to submit a report on the conduct of the criminal. If the conduct of the criminal is good, then they think that that is a mitigating factor. So what are the mitigating factors in the case of each and every convict? That will be considered by the court, the appellate courts. So in this case, we find the trial court has sentenced all the 9, okay, but it has to be confirmed by the High Court. In this case, the Madurai bench of the Madras High Court. So we also find that, interestingly, the Madurai bench of the Madras High Court took suo moto notice in this case, and the case was handed over to the CBI by the previous government. So there may be people who will say that, oh no, how come Madurai bench of the Madras High Court, after taking suo moto notice, can they be the right authority to confirm this sentence or not? So that's a debate which is different from the present sentencing part. So how did the trial court arrive at this decision? So one has to read the judgment carefully and see whether in each of the convicts the court had found enough reasons, because section 354(3) of the CRPC clearly says special reasons have to be given for death sentence. So are there any special reasons which are recorded for each and every convict in this case? These reasons cannot be uniform for all the 9. They have to be specific. So that is why one has to read the judgment carefully to find out whether the death sentence is justified. It's not. Yeah.
In this case, accused are not a common people. They are the well-known police personnel. So is it possible to upper court can reduce the quantum of punishment or strike down the double hang or something like that?
See, one has to understand the context. So the fact that the state was behind this, the accused policemen are not policemen,
Exactly.
Private policemen. They represented the state. So the state was behind the custodial violence. So that is why the judge must have imposed death sentence, which is the highest form of punishment. Because Bachan Singh judgment of the Supreme Court clearly says death sentence can be imposed only if the alternative is indisputably foreclosed. So, what is the alternative to death sentence? Life sentence. So, life imprisonment must be indisputably, unarguably closed, foreclosed. Only then death sentence can be given. But in this case, is that correct decision? One has to read the judgment carefully to find out whether the judge has given enough reasons for this. Because custodial violence is not an ordinary murder, because the state itself is responsible. So
Yeah,
the judge must have thought we must send out a very strong signal to the society, to the police force as such, that this
yeah.
cannot be tolerated. So that is the reason behind this death sentence. But is death sentence on a principle level? I wanted to ask whether it is a deterrent. What is the example? What is the international examples say? So there are many arguments against death sentence in principle. But these reasons for against death sentence can carry weight only when the society and the state, they are against the custodial violence as such, which is a serious thing. In this case, what was the offense of these two people who were killed? They were just accused of violating COVID-19 guidelines. Uh,
Yeah,
so
norms.
and that was also proved to be false allegations. Therefore, so the extreme nature of the violence, custodial violence, has shaken the conscience of the society. But is this comparable to what we witnessed earlier, the Nirbhaya case? That also shocked the conscience of the society. So
Okay.
the courts very often consider this factor as, is the society's conscience shaken by this crime? Not only that it's gruesome, heinous, etc., but it should shake the conscience of the society. So that is another aspect which will come into the play when the case is
The
taken to the
judge
appellate
went
court.
into great, yeah, the judge went into great details explaining why life imprisonment was insufficient and why incident warranted by maximum punishment. How significant this verdict in the history of judicial response, and what's your take on police brutality in India?
See, police brutality as such, requires, yes, separate discussion as such. In the sense, custodial violence, we don't have a standalone law against torture, because we have signed the international agreement against torture, but we have not ratified it. So that is one reason why many civil society, civil liberties activists, they have been asking for a standalone law in India against torture as such. So if you look at this case, the CBI invoked the ordinary murder provisions in the Indian Penal Code
Hmm.
against this accused. But did we have a standalone law against custodial torture, we could have found this accused guilty earlier than what we could achieve so far. So therefore, the reason why it took, maybe it took so long, it happened in 20 and 6 more long years. Now they will go to high court, after that they may go to Supreme Court also. So finally it will be decided here, so which means another 5 years. So that is lot of going to be a lot of public debate on this merits of death sentencing as such. But the main thing, according to me, is to assess whether the court has sufficient reasons for each of these convicts, you know, and are these reasons specific to each of these convicts? Whether each of them had this rarest of rare reason. That is what the court has to show. So one has to read the fine print of the judgment to find out whether the court has given rarest of reason for each of these convicts, not uniform across the board. That's very important.
The FIR filed by the Sathankulam police claimed that the father and son rolled down the road and sustained injuries themselves, leading to their deaths. But unfortunately, and they how they get caught means entire police force trying to erase the evidence, and some shopkeeper actually produced a lot of CCTV footages, which is helped this in this case to pursue against the police officials. So many human rights activists still claim that not every and each police station in the country yet to be properly covered by CCTV, despite of Supreme Court orders.
Correct.
So,
Right.
what kind of system should be in place?
See, there is already a case, being heard by the Supreme Court about the CCTVs. CCTVs in every police station.
Yeah,
So in this case, we find that the CCTV evidence was erased.
yeah.
Correct. So therefore, whether the
Against
death
police bleeding.
penalty, yeah, death penalty will it deter policemen in the future from inflicting violence, custodial violence on the innocent people? No, that there is no answer, because the way the laws function here in India, we don't have a standalone law against custodial violence. That is the main problem, not the absence of death penalty. The fact that death penalty is commuted at the appellate courts should not mean that there is a setback. What we require against custodial violence is that we should have a strong standalone law. Correct. So
Yeah.
it's not the court's inability to, appellate court's inability to confirm death sentence.
Mm-hmm.
That would be
Even,
my argument.
sir, one more area we have to discuss about that. Even in their even the father and son severely injured condition following by the brutal assault by the police, Jayaraj and Benicks were produced before magistrate for remand. Number one, and according to the reports, that magistrate did not appear to take custodial physical states of seriously at all. So they gave a fits. They issued a fit certificate for both. So, in your consideration opinion, what kind of corrective measures should be taken in the judiciary as well as medical fraternity?
So this case should offer great lessons for state as well as for the civil liberty groups. The lessons for the state is that the state should come forward on its own after consulting stakeholders to enact a standalone law against custodial violence. There have been number of cases. I was told that within 8 years, last 8 years, from 2015 to 2022, there have been 20,000 cases of custodial deaths which have been reported to the National Human Rights Commission. So none of these cases have come to the conclusion as the Sathankulam case.
Yeah.
So what does it show? That even if the death sentence is implemented, enforced for all the 9 convicts, I don't think it will deter policemen from indulging in custodial violence because of this death sentence. Because as a mature democracy, we cannot show death sentence as an answer for custodial violence. Death sentence, courts don't give randomly like this. It happens very, very rare. So if there are 20,000 cases which have been reported to the NHRC, is it possible to award 20,000 death sentences? No, I don't think it is possible. We are a mature democracy. So we have to find other, legal solutions to this. What are the legal solutions? Is to enact a standalone effective law. And why not India ratify this anti-torture international agreement? We have been avoiding it. After signing it, the ratification is another measure which is required to make it mandatory to enforce it across the nation, the international instrument. But we are reluctant to ratify that. So as people, as the civil society groups, they should campaign for the ratification of the law, the
So,
international law.
do you think only sustained judicial monitored or police reform can prevent such a tragedy in future?
It is a long road for reform, and there was a petition in the Supreme Court, filed by former law minister Ashwini Kumar. He was a Congress minister. He had petitioned the Supreme Court for a law against custodial torture. But the Supreme Court said, sorry, we can't interfere in this. It is Parliament's domain. Parliament has to enact a law. If the Parliament sees wisdom in your plea, then they may enact the law. But it does not happen so far. The Supreme Court didn't want to interfere in this, because what the most Supreme can do is to ask Parliament to enact a law. So why should the court interfere in this? So that is how it went. But nothing prevents the Supreme Court, from laying down effective guidelines against custodial torture. So Supreme Court has interfered in many cases like this, where Parliament has not stepped in and enacted a law. Supreme Court has stepped in and filled the gap by laying down guidelines, as happened in the Vishaka case, where there was no sexual harassment law against sexual harassment in 2000. But Supreme Court had intervened and laid down guidelines, which were later, changed as laws by a law made by Parliament in 2013. Therefore, there is scope for judiciary to interfere and lay down guidelines till such time when Parliament enacts a law, uniform law across the country against custodial violence. And the time has come for the Supreme Court not to wash its hands off this tragedy, but take it up and suo moto perhaps, and evolve uniform guidelines across the nation against custodial violence. And that will be the greatest tribute to those two persons who died in this unfortunate tragedy.
Thank you so much for your insights, sir. Thank you so much.
Thank you.